After the January 6th riots, the U.S. Department of Justice began charging anyone they thought had participated, but not just for the crimes they committed. According to the DOJ, anyone who showed up at the Capitol had corruptly obstructed or impeded an official proceeding, which was punishable by a fine and imprisonment for up to 20 years. Many claimed that the DOJ was overcharging these J6ers, misusing the law to punish dissenters. When it comes to 18 U.S.C. 1512C, SCOTUS agreed. So we'll discuss that next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach the rising generation to be free. I'm glad you could join me today. Today, we realize that context matters. The whole scope of this argument before the Supreme Court, the decision, comes down to context. I use the example of, say you walked in on a conversation I was having with someone when I said, I beat my wife. Sounds pretty awful, right? Until you realize that we were talking about the fact that we played cards every night, my wife and I beat her every night. Context matters. And it matters in this case. And it matters in the law. So we're going to take some time. And, I'll talk more about the website and other things that we're doing at the end of the episode. But for now, let's take a look at this 1512C law and what the Supreme Court said it actually meant in regards to the January 6th defendants. Before we get into this case, there's a fundamental problem in all the parts of this opinion. Chief Justice Roberts wrote in the opinion, on that day, Congress convened in a joint session to certify the votes of the 2020 presidential election. Justice Jackson wrote in her concurrence, on January 6, 2021, an angry mob stormed the U.S. Capitol, seeking to prevent Congress from fulfilling its constitutional duty to certify the electoral votes in the 2020 presidential election. And Justice Barrett wrote in her dissent, at the time, Congress was meeting in a joint session to certify the Electoral College results. Do you see the mistake? Congress does not certify the votes of the presidential electors. From the 12th Amendment, we read, the President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates and the votes shall then be counted. Congress is not present to certify the election, but to observe the votes being counted. The two houses of Congress do have one additional function they may need to perform, though. And if no person have such majority, then from the persons having the highest number not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president. And if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. While not directly related to the facts of this case, the fact that all 9 justices of the Supreme Court placed their name on some part of this opinion that falsely claims that Congress has the authority to certify and by extension overrule the votes of the presidential electors should give us all pause. Now consider how many filings, briefs, complaints, and opinions have been filed as this case worked its way through our judicial system with the lie as part of it. If you're going to charge someone with a crime, at least you can do is get the circumstances around the alleged crime correct. Now, with all of the controversies, allegations, and shouting back and forth, I've seen one question come up time and time again. Are the J6ers being overcharged by the Department of Justice? One of those accused of a crime punishable by up to 20 years in prison is Joseph Fisher. According to the complaint, about an hour after the House recessed, Fisher trespassed into the Capitol and was involved in a physical confrontation with law enforcement. Fisher claimed in Facebook posts that he had pushed police back about 25 feet and that he was inside the Capitol talking to police. Body cam footage shows Fisher near a scrum between the crowd and police who were trying to eject trespassers from the building. A grand jury returned a 7-count superseding indictment against Fisher. 6 of those counts allege that Fisher forcibly assaulted a federal officer, entered and remained in a restricted building, and engaged in disorderly and disruptive conduct in the Capitol, among other crimes. Those 6 counts carry maximum penalties ranging from 6 months to 8 years in prison. Mr. Fisher has been charged with a total of 7 counts, 6 of which range from relatively minor to moderately serious. However, this case revolves around a single count in the indictment. In count 3, the only count now before us, the government charged Fisher with violating 18 U.S.C. section 1512c2. Fisher moved to dismiss that count, arguing that the provisions criminalized only attempts to impair the availability or integrity of evidence. The district court granted his motion in relevant part. It concluded that the scope of section 1512c2 is limited by subsection c1 and therefore requires a defendant to have taken some action with respect to a document, record, or other object. A divided panel of the D.C. Circuit reversed and remanded for further proceeding. Judge Pan, writing for the court, held that the word otherwise in section 1512c2 means that the provision unambiguously covers all forms of corrupt obstruction of an official proceeding other than the conduct that is already covered by 1512c1. Judge Walker concurred in part and concurred in the judgment, but he read the mens rea element of the statute corruptly as requiring a defendant to act with an intent to procure an unlawful benefit. The crux of the matter is the 3rd count in the indictment, a violation of 18 U.S.C. section 1512c2. What is 1512c2? Let's start with a little context. Section 1512 is entitled Tampering with a Witness, Victim, or an Informant. Section 1512 is about tampering with a witness, a victim, or an informant. Now, within this section, we find subsection C. Whoever corruptly, 1. alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes an official proceeding or attempts to do so. While this may seem to be a small point, the context of the law matters. In this case, it all comes down to the scope of the word otherwise. The controversy before us is about the scope of the residual otherwise clause in section 1512c2. On the one hand, Fisher contends that C2 applies only to acts that affect the integrity or availability of evidence. On the other, the government argues that C2 captures all forms of obstructive conduct beyond 1512c1's focus on evidence impairment. Isn't it amazing how 20 years of this man's life and the life of others who have been similarly charged can come down to the meaning and context of a single word? The history of this law goes all the way back to the early 2000s, after the Enron and other accounting scandals. U.S. Senator Paul Sarbanes and U.S. Representative Michael G. Oxley sponsored a bill in 2002 called Sarbanes-Oxley, or SOX. The Sarbanes-Oxley Act of 2002 imposes criminal liability on anyone who corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so, with the intent to impair the object's integrity or availability for use in an official proceeding. The next subsection extends that prohibition to anyone who otherwise obstructs, influences, or impedes an official proceeding or attempts to do so. There's a bit of a problem already with the Sarbanes-Oxley Act. Subsection C1 criminalizes the destruction of records, but is part of a section of the law regarding tampering with witnesses, not records. They could have placed the language in Section 1510, obstruction of criminal investigations, or Section 1519, destruction, alteration, falsification of records in federal investigations and bankruptcy. Instead, they put this document tampering language in a section of the law dealing with witness intimidation. Petitioner Joseph Fisher was charged with violating 1512c2 for the conduct on January 6, 2021. On that day, Congress convened a joint session to certify the votes in the 2020 presidential election. This breach of the Capitol delayed the certification of the vote. The criminal complaint alleges that Fisher was among those who invaded the building. Fisher was charged with various crimes for his actions on January 6, including obstructing an official proceeding in violation of 1512c2. The breach of the Capitol did not delay the certification of the vote because, as I've already pointed out, Congress doesn't certify the vote. The breach did delay the counting of the votes, but while Mr. Fisher's actions may have extended the delay, it did not cause it. As the complaint stated, Mr. Fisher did not enter the Capitol until an hour after they had recessed. However, that is not why Mr. Fisher challenged this count in his indictment. He moved to dismiss that charge, arguing that the provision criminalizes only attempts to impair the availability or integrity of evidence. The district court granted his motion in relevant part. A divided panel of the D.C. Circuit reversed and remanded for further proceedings. Which brings us to the critical word, otherwise. Section 1512c1 describes particular types of criminal conduct in specific terms. The purpose of C2 is, as the parties agree, to cover some set of matters not specifically contemplated by C1. Perhaps Congress sought to criminalize all obstructive acts in 1512c, and having named a few examples in C1, devised C2 to prohibit the rest. But C2 could have a narrower scope if Congress designed it to fill inadvertent gaps in the focus language of C1. Did Congress mean to criminalize all obstructive acts, or was subsection C2 only meant to fill in any gaps left in C1? How does the court perceive the intent of Congress? One way to discern the reach of an otherwise clause is to look for guidance from whatever examples come before it. Two general principles are relevant. First, the canon of noscitur et sociae teaches that a word is given more precise content by the neighboring words with which it is associated. And under the related canon of e jurisdictum generis, a general or collective term at the end of a list of specific items is typically controlled and defined by reference to those specific items that precede it. These approaches to statutory interpretation track the common sense intuition that Congress would not ordinarily introduce a general term that renders meaningless the specific text that accompanies it. Have you ever wondered why attorneys and judges like to use fancy Latin sayings rather than simple English? If you look at the definitions of both noscitur et sociae and e jurisdictum genere, they mean pretty much the same thing. You define an ambiguous word by its context. Under these principles, the otherwise provision of 1512c2 is limited by the list of specific criminal violations that precede it in C1. If, as the government asserts, C2 covers all forms of obstructive conduct beyond 1512c1, focused on evidence of impairment, Congress would have had little reason to provide any specific examples at all. And the sweep of subsection C2 would swallow C1, leaving that narrower provision with no work to do. I've seen this argument before with the General Welfare Clause. If the framers of the Constitution meant the General Welfare Clause authorized pretty much anything Congress thought was good, why follow it with 17 specific powers? Back to the court opinion. It makes sense to read C2 as limited by C1 in light of the history of the provision. The Enron accounting scandal exposed a loophole in 1512. At that time, the statute imposed liability on anyone who, among other things, corruptly persuaded another person to shred documents, but it curiously failed to impose liability on a person who destroyed records himself. The parties agree that Congress enacted 1512c as part of the broader Sarbanes-Oxley Act to plug this loophole. It'd be peculiar to conclude that in closing the Enron gap, Congress created a catch-all provision that reaches beyond the scenarios that promoted the legislation. By reading C2 in light of C1, the court affords proper respect to the prerogatives of Congress in carrying out the quintessentially legislative act of defining crimes and setting the penalties for them. As Chief Justice Roberts writes in the opinion, C2 of 1512 must be read in the light of C1, leading to the following conclusion. To provide a violation of Section 1512c2, the government must establish that the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or as we earlier explained, of the things used in the proceedings or attempted to do so. The judgment of the D.C. Circuit is therefore vacated, and the case is remanded for further proceedings consistent with this opinion. On remand, the D.C. Circuit may assess the sufficiency of Count 3 of Fisher's indictment in light of our interpretation of Section 1512C2. It is so ordered. So Mr. Fisher's case goes back to the Circuit Court to be heard again. This time, though, the Circuit Court is to follow the opinion of the Supreme Court and read subsection C2 in the light of subsection C1. Now, Justice Jackson wrote a concurring opinion. Now, while she comes to the same conclusion as the majority, she also brings up a couple of interesting points. On January 6, 2021, an angry mob stormed the United States Capitol seeking to prevent Congress from fulfilling its constitutional duty to certify the electoral votes in the 2020 presidential election. The peaceful transfer of power is a fundamental democratic norm, and those who attempt to disrupt it in this way inflict a deep wound on this nation. But today's case is not about the immorality of those acts. Instead, the question before this court is far narrower. What is the scope of the particular crime Congress has outlined in 18 U.S.C. Section 1512C2? Yes, the peaceful transfer of power is fundamental to our norms. However, the transfer should not only be peaceful, but must be legal. While a small group of agitators did storm the Capitol, the question that seems to be lost is whether the purpose was to disrupt the peaceful transfer of power or to disrupt the illegal transfer of power. This gets to the mens rea of 1512C. Whoever corruptly. Now, mens rea is Latin for criminal intent. Well, I agree that many who entered the Capitol on January 6 committed trespasses, some even vandalism. Was the intent of the group as a whole corrupt? If you have evidence that the elections in many of those states had violated state law, then it was the elections that were corrupt, and attempting to stop their use was both ethical and moral. If, as I have shown at the time, several of the states had appointed presidential electors in manner other than the one directed by their legislature, then those electors were corruptly appointed and should not be counted. Working to prevent that was not a corrupt attempt to impede an official proceeding, but an attempt to stop the corruption of that proceeding. Our commitment to equal justice and the rule of law requires the court to faithfully apply criminal laws as written, even in periods of national crisis, and even when the conduct alleged is indisputably abhorrent. Justice Jackson is correct. The rule of law requires courts to follow the law as written. There is no exception clause for national crises or emergencies. I only wish the court would have remembered that when the so-called national emergencies have been invoked in our recent past. Justice Barrett wrote a dissent which Justices Kagan and Sotomayor joined. In her dissent, Justice Barrett wrote, Joe Fisher allegedly joined a mob of rioters that breached the Capitol on January 6, 2021. At the time, Congress was meeting in a joint session to certify the Electoral College results. The riot forced Congress to suspend the proceedings, delaying it for several hours. The court does not dispute that Congress's joint session qualifies as an official proceeding, that rioters delayed the proceeding, or even that Fisher's alleged conduct, which includes trespassing and a physical confrontation with law enforcement, was part of a successful effort to forcibly halt the certification of the election results. Given these premises, the case that Fisher can be tried for obstructing, influencing, or impeding an official proceeding seems open and shut. So why does the court hold otherwise? Because it simply cannot believe that Congress meant what it said. Section 1512C2 is a very broad provision, and admittedly, events like January 6 were not its target. Who could blame Congress for that failure of imagination? But statutes often go further than the problem that inspired them. And under the rules of statutory interpretation, we stick to the text anyway. The court, abandoning that approach, does textual backflips to find some way. So why do Justice Barrett, Kagan, and Sotomayor not understand that taking a subsection of law out of context is not only judicial malpractice, but certainly bad behavior? I believe is because it does not get them to the outcome they desire, the severe punishment of those who would challenge an election with physical intervention. There is no getting around it. Section 1512C2 is an expansive statute. Yet Congress, not this court, weighs the pros and cons of whether a statute should sweep broadly or narrowly. Once Congress has set the outer bounds of liability, the executive branch has the discretion to select particular cases to prosecute within those boundaries. By atextually narrowing Section 1512C2, the court has failed to respect the prerogatives of the political branches. I respectfully dissent. Yes, 1512C2 is an expansive statute. Expansive is defined as having a capacity or tendency to expand. Subsection C2 expands C1. Both subsections expand subsection C, which itself expands Section 1512, whose stated purpose is to define and set punishment for tampering with a witness, victim, or an informant. What Justice Barrett is attempting to do is expand C2 beyond its context and pretend it's a statute all to itself. Now, what can we conclude from this decision? First and foremost, that everyone deserves due process, regardless of how despicable we think they may be. Remember, no matter how badly you want someone to pay for their actions, there's probably someone out there who feels the same way about you. If we start denying due process to people for any reason, then we are no longer a nation of laws and justice. We've become just another banana republic. Second, when trying to understand laws, we must read them in their context. This is not the first argument someone has made that looks at a single clause, line, or phrase out of context in order to get at what they want, and it won't be the last. Lastly, everyone who has been charged with a violation of Section 1512C2 in connection with January 6th can use this opinion to move that those charges be dropped. Any other charges may proceed, after all, since they are alleged to have committed those crimes, but they do have evidence that their 1512 charges should be dropped. Now, I'm sure this is not the last we'll hear of January 6 prosecutions. However, we should celebrate the seeking of justice and the rule of law when we see it, especially at our nation's highest court. January 6th certainly is the gift that keeps on giving, and I doubt we're done here. But it's important to recognize just because you see something as evil doesn't mean you get to throw the kitchen sink at them. You have to throw laws of what they've actually violated. And I'm sorry, 1512, the context of 1512, says that what the January 6ers did that entered the Capitol and disrupted the joint session of Congress doesn't fit. There may be other laws that they have violated, but that one just does not fit. I know the dissent wants to pretend that 1512C2 is a statute all on its own. It has no context, which really doesn't make any sense since it's a subsection of a subsection of a section of the law. We got to look at the context. Now, I hope you understood what's going on here, because it is a fundamental question of justice of what you can be charged with. Now, if you'd like to see more, please head to the website, constitutionstudy.com. Find the article. You'll find all the quotes, including the links to my source material. Now, if you'd like to support the Constitution Study, I hope that you would, well, just head to constitutionstudy.com/shop. You can make a one-time or recurring donation. You can purchase books, T-shirts, mugs, anything like that. All that money goes to keeping the Constitution Study up and running. I don't draw a salary or take any payments from it. You can also support the work that we're doing here by using your cell phone. See, Patriot Mobile is the only Christian conservative wireless carrier in the country. They support those who are supporting their constitutional rights. And if you go to patriotmobile.com/constitution and you sign up, guess what? They help support the Constitution Study as well. By the way, use the promo code Constitution at checkout, and you'll get free activation. There you get to, not only do you get to support the Constitution Study, but you get great cell phone coverage and service as well. Regardless of what you decide, I hope you'll take this information and share it. I was at a recent get-together with some friends, and it was good to exchange information and ideas, and to help expand people with the idea of what the Constitution actually says, not what they've been told it says. You can help. You can also help by coming back here next time for the Constitution Study.